We are actually, looking more and more careful because we see that personal data and big data, when you have a lot of personal information, can be a barrier to entry for other companies. It can be a very, very strong asset when it comes to innovation. So far, we haven't had cases where it was data issues that sort of really was the make or break in any transaction. But we are looking for it because we see that it becomes a more and more important asset in a number of different sectors, actually.
Yeah, certainly. We're looking at Germany for a case in point. They are analysing whether Facebook perhaps has looked at forcing its users to sign unfair privacy agreements. Is this something that you might be looking at from an EU-wide level?
Well, actually, we have asked the Germans to look into these issues, both with a German legislative perspective, but also with a European perspective, in order to make sure that we work efficiently and divide labor whenever due. And this is a very interesting probe because they are looking at the interface between privacy and competition law to see if the fact that Facebook is very dominant in some markets has allowed them actually to make their users accept less protection of their personal information that they would otherwise have due to the legislation.
Digging into Facebook a little bit more, of course, you've been looking at the WhatsApp deal signed back in 2014. Has the company responded to potentially some of your objections regarding the data that they provided and the viewpoints they put forward during the transaction?
Well, we're still in the middle of that sort of process investigation, so it is too early to say. But we put a lot of efforts into this because obviously it's very, very important for us to have correct information because we base our investigations of the fact of the case, the evidence, the information that we get from the companies when we do a merger control. And therefore, obviously, for us it's very, very important if we find out or get a concern that we weren't given the right set of evidence and facts when we did the merger control. And therefore, of course, for us, this is high priority, and we try to do it as quickly as possible.
And you're hoping this sends a sign out to those companies that are looking at doing deals that transparency is the key?
Well, transparency with us is the key because obviously we are very, very committed to protect also the confidentiality in these transactions. We put a lot of effort into making sure that there is no leakages, that you can actually have a trusting working relationship, even though we may have different responsibilities in the process of merger control. But it is very important for us to have correct data, full information, in order for us to work in a way that will actually also make things happen in a constructive way, making sure that we can do our job in a speedily and qualified way.
When looking at another key tech giant, of course, Google is Alphabet-owned. Google is something that you, of course, delve into on various types of issues. There's two Google cases out there at the moment, particularly regarding Android phone software and advertising. These are contract-based. Does that ever affect whether you incline to settle with a company or indeed impose fines? Where do you stand on the two outcomes?
Well, the two cases, the AdSense case and the Android case, they are newer than the Google search case. Google have received statement of objections in both cases. We have their answers, but we're still in the process of analyzing those answers, and therefore, basically, it is open as to where those two cases will go at the moment.
Are US companies in general, the big tech giants that you speak to, generally very forthcoming with help and responsiveness to the EU Competition Commission?
Yes, in general, I think so. Of course, we have different responsibilities, the businesses to their owners and shareholders, us to the citizens to enjoy the fruits of fair competition, of innovation, quality, affordable prices. But I think there is a respect of the different responsibilities and very often a constructive working relationship.
Sometimes it seems as though companies against, for example, Google, concerned about photos, concerned agencies there, particular publishers. It seems to go from maybe not always in the realms of antitrust, but they seem to be looking to the antitrust commissioners to help with their plight, whether it's actually something more to do with contract overwriting. What do you believe about the antitrust issue here? Is it an antitrust issue when it's perhaps more about copyright?
Well, we of course have to be very thorough before we open a case, because copyright is copyright and antitrust and antitrust. And even though the competence and the forces to enforce competition law is very strong in Europe, that doesn't mean that every question becomes a question of competition law enforcement. And therefore, of course, we try to be very precise in making sure that we do not use our antitrust tools when it's a copyright issue or when it's an issue of how contract has been made, and that of course we also try to be very open with people who come to us and have concerns or want to complain, to say, well, something we can look into, and other things, well, they are for other authorities.
Oh, how is Europe when it comes to the companies, the governments, when they come to you with complaints about some of the United States tech giants? Do you feel sometimes they were over-protectionist, or usually the viewpoint's valid?
Well, of course, it takes some solidity in a complaint for us to start investigating, because we need something to go on before we go there. But the thing is, and you probably know that some of the complainants in the first Google case, well, they are US companies, yes, but also active in the European market. So I don't see that the flag or the nationality of the company plays a role. It's the behavior in the marketplace that makes people concerned, and that sometimes triggers a complaint.